My lord, in this matter, I am led by Mr. Owen Banerjee. He is on his legs at court room number 1. I pray for a short passover, section 9 matter.
Passover at this time?
Very short passover, yes.
We will have it tomorrow then.
My lord, then day after tomorrow.
Day after tomorrow.
Look, for this item, I am the petitioner. I am saying not today. Only not today.
Not today. Not today.
My lord, I am for the respondent, my lord. Well, there's a revision application pending before Honorable Justice Shankar Sarkar, my lord. My lord has previously directed to adjourn the matter to upon completion of the proceeding. This pending, the next date has been fixed on 19th of January at 2 p.m., my lord. Is the ordership, my lord. Any day thereafter can be.
None appears for the petitioner. Let this matter be listed on. When do you want?
Monthly list of February, my lord.
None appears for the petitioner. It is contended by the learned counsel for the respondent that the revision petition CO number 147 of 2025 is listed on 19 January 2026. He prays for the listing of the present petition. In view of the same, let this matter be listed in the monthly list of February. You are for the
I'm for the respondent.
monthly list of February.
My lord, I am the applicant. This matter, my lord, after hearing a filing of affidavits, matter is ready for hearing. It was taken up on 1st December. Your lordship fixed it today, and my lord, I can proceed because matter has been pending section 9 since my lord November 2024. My lord, I've in fact completed my submission before the previous bench. And then your lordship may recall I made that submission, but my lord, because there's no partner, it came to your lordship. Your lordship has fixed on 1st. Your lordship fixed it today. So,
I
my lord,
appear for the respondent. I'm being led by Mr. Anipan Ray, lordship. I was praying that if it can be fixed after 9th, your lordship is not available till 9th.
It was fixed at his instance because on that day also I was willing to proceed. I can. Well, it will take some time. I can.
I'm also being led by Mr. Ray. Mr. Bose can proceed if it commends to my lord.
I can make my submissions because it'll take some about 1,200 crores of rupees is due. That's, my lord. They say there is no arbitration, and my lord, may I proceed with this?
Lord, kindly give us some other short date to this.
Yes, that's okay. I mean, it's up to 3 anyway.
I don't think so. Mr. Bose can complete the submissions in. I'll take the non-commercial at 3 o'clock.
Yes.
Very well. Very well.
No, my lord, I'll tell you the history. These SREI companies, I don't know whether your lordship has had the occasion to deal with these SREI companies. My lord, these
not that much, only to the extent.
To the extent, this is very important because, my lord, when you talk about so many crores of rupees and there is nothing, no asset of the respondent, then you think, where has the money gone? My lord, so this company, this Srei, obviously there are three agreements,
Yes.
my lord. The Srei, because of the promoter directors defalcating money, my lord, the Reserve Bank of India, my lord, under its powers, under 45E, appointed an administrator over this company, my lord. And there is a provision, my lord, in the Insolvency Act that you can, the Reserve Bank of India filed after appointing its own administrator that this company should be, the insolvency proceeding should be started. So Reserve Bank of India in October, mark the words, dates, my lord, October 2021, my lord, filed an application before the National Law Tribunal,
Yes.
Company Law Tribunal, and my lord, there's an order of 8th October 2021 appointing the same administrator of Reserve Bank of India as the what we call resolution professional, as administrator. This was going on, and because the date is very important, October 2021, because the nature of allegation is promoter directors were siphoning of funds from this company. And after this, the resolution, administration process came to an end, in around about August 2023, 11th August 2023, when NARCIL, which is a consortium of banks, of national banks, took over this, the new management. I appear on behalf, fortunately for the new management, after this consortium of banks have taken over. It's called NARCIL. Whatever it is, it's a company, remains as a company. So I must defend it as a company now, because because of the nature of allegations which I made, the funds where it has gone, and who really is the respondent, is of some material, and that's why I'm introducing. Now, so what happened? The formal order handing over came in February, I believe January 2024 or February 2024. That the board was constituted. People from the various banks, NARCIL, so although the formal order is of since August 2023, the formal order, the board constitution, is from February 2024. During this process of reconciliation of accounts, many things surfaced. Forensic audit, etc., was done. And this is one such thing which has come, and we have filed this application under section the 9, I believe in November or October 2024, because it's gone. The money is gone, just gone. 1,200 crores. Where it is gone, I will find out. That's a question, of the other agencies taking over. I don't know, because I must follow the law, and the law must take its course. So, so there are three agreements. The three agreements for loan are dated 1st April 2019. All three agreements.
All
three same date. My lord, page 24 of the petition is the first one agreement, 240 crores. I'll just, indicate the fight. 240 crores, page 24 of the petition.
Yes.
240. My lord, I did not buy, it was not annexed in the original section 9, so I took leave to file a supplementary affidavit, which was granted. So, my lord, supplementary affidavit, page 5, will give you the second agreement. It's for 230 crores.
So 240, 230.
230. Page 5, supplementary affidavit.
Page
5 of the supplementary affidavit will give you 230 crores.
Same date, first April.
Yes, my lord. I will tell you where the money has gone, my lord, later. Huh? Now, my lord, well, I do not know where the money has gone. That's for, but there are enough indications. Now, my lord, the third agreement is at page 94 of the supplementary affidavit, is for 225 crores of the supplementary affidavit.
Supplementary affidavit ek volume aur hoga.
Oh, sorry. Yeah, many volumes are there because agreements are, may not, voluminous. But correspondence, very minimal.
Page
My lord, page 90, one is page 5, another is page 94. My lord, it's identical. At page 94. My lord,
25. So 240, 230, 225.
225. My lord, they add up to 695. My lord, if you look one of the agreements,
Yes.
there is something called the DSR. DSR is debt reserve. Debt reserve ratio. Debt servicing reserve. What is debt servicing reserve? My lord, that you must always service. My lord, 12 crores. 12 crores, my lord, will go on. My lord, there's a definition of debt servicing reserve. So, my lord, for the first agreement, debt servicing reserve is 12 crores. For the second agreement, it is 11.5. My lord, the third one is, my lord, again 11.5, adding up to 35 crores. Therefore, my lord, during this time, you must ensure that this is maintained. That is the servicing reserve. My lord, it is something, he says, contingency or whatever it is. Now, my lord, if you take one of the agreements, and that's a petition, and I think I won't trouble your lordship with the rest of the supplementary affidavits. My lord, page 26. If you, page 26, one of the, you will find right at the end, there is something called debt service reserve. Shall mean debt service reserve required to be created, maintained by the borrower within 7 days for equivalent to 12 crores. 12 crores, which will carry interest of 12%, will be payable, etc., etc. Has your lordship found this?
Yes.
So, my lord, at all material times, you must maintain 12 crores. 12, 11.5, 11.5 comes to, my lord, 35 crores. Then, my lord, there is a definition of financing documents, page 28. Financing documents, page 28. It says, shall mean collectively the agreement, the other security documents, and such documents that may be required obtained under this agreement and other financing documents to perfect, validate this agreement and other financing documents protect under this. So, financing documents include basically everything. My lord, hypothecation, everything, whatever it is. This is the definition. Please remember, my lord, it has some impact because of the arbitration clause, which I will show you. My lord, then, my lord, how is debt, my lord, page 41 and 42? My lord, 2.11, small I. The borrower shall on the prior initial disbursement date create and thereafter maintain at all times until the final settlement date the DSR. So they have to maintain the DSR in such form to the satisfaction of the lender. And may not kindly see II. The borrower agrees, small a, the amounts accumulated shall be utilized as provided under this agreement and the financing documents. And B says DSR shall be utilized only in the case of shortfall in cash flows for meeting the debt service from time to time. So, my lord, if you fail to maintain this, I will adjust from the debt reserve ratio. This is what is meant, my lord, in small b. Then in small c, if at any time any amount is so utilized, borrower shall immediately credit the designated or as such account as may be advised so utilized. So, my lord, it means that whenever you are not maintaining, you are going out of bound, my lord, I will adjust from that ratio and you have to replenish that ratio, that reserve. And, my lord, of course, termination. And, my lord, 2.12 says interest, penal and all charges, expenses shall accrue from the date and computed from the date of 61 days, etc., etc. My lord, I don't know why it is. It's not. Then, my lord, what happened is something fantastic. Remember, my lord, the date which I mentioned, October 2021. And, my lord, there is, of course, this clause he wants to show about page 46 in all of these agreements. My lord, obligation will be secured by what? Hypothecation of movable current assets, both present and future, receivable, etc. Now, my lord, no mention about any asset, both current and if you don't have anything, there is something. So, for this loan has been given. Now, my lord, we find from here, from the papers, after all this, remember the time, my lord, October 2021, when it surfaced. And I believe the administrator was appointed sometime in March 2021 by Reserve Bank, later on perfected by the National in October. My lord, a master agreement dated 31st March 2021 surfaces. Please note the date, 31st March 2021. That you will find, my lord, at volume 282, volume 3, page 282.
Volume 3.
Volume 3, page 282. Because by this agreement, my lord, the entire loan of two principal gets practically wiped out. And, my lord, it is reduced to 300 crores, which I will show you. And balance is on redeemable debentures of one HON'BLE company. My lord, redeemable after 10 years, which incidentally, my lord, is in liquidation. My lord, that is a separate issue. I will show you first clause 5 and 6, page 283. My lord, page 283. Kindly take a note, my lord. It says small b, my lord, after quoting that there are so many, 1, 2, 3, they quote the 3 loan agreements.
Yes.
My lord, has you found it? My lord. Then B says, subsequently, clause 5. The parties have mutually agreed when, my lord, 31st March 2021, restructuring the loan by combining a part of the loan that is in all these outside, and the resultant figure is now suddenly becoming from 695 crores 340 crores and the next part is 6. Borrower has agreed to transfer some cumulative convertible debentures, face value 10, with encumbrances equivalent to 490 crores, being the balance as per Article 6.17. So, my lord, what is 6.17? My lord, if you come, please, to clause 6 once, which is, my lord, কোথায় 6 টা? So I'm sorry, my lord. Before that, my lord, page 289. Page 289. 289.
289.
Yes.
Yes.
কোথায় আছে? কোথায় আছে? Yes. My lord, issuer, yes, I'm sorry, thank you. My lord, issuer of these debentures shall mean Hiranmaya Energy of such and such, having such and such. So, someone is giving, my lord, I am getting for the balance, my lord, it's now reduced to 290, and balance, my lord, which at the moment it's dead because it's gone into liquidation. That's neither here nor there. I will show you who Hiranmaya is. That is a separate chapter altogether. Now, my lord, this company issuer is these shares, and you can find out these loan agreements which I have. Then, my lord, page 289, it says the restructuring. In the restructuring, very important is what is meant by the loan agreements under this. Please make a note. It means loan agreement 1, 2, 3. It's being restructured. So loan agreements mean loans 1, 2, 3. Then, my lord, 337. The arbitration clause is there, or rather, my lord, before that, 288. My lord, just have a look at what is meant by financing documents under the restructuring agreement. Page 288. My lord, financing documents mean such documents as may be executed or obtained under this agreement and other financing documents to perfect this agreement, which means, my lord, all the 3 loan agreements. 1, 2, 3. My lord, this is important. Financing documents mean in C, such documents executed, obtained under this document and other financing documents to maintain this. This is why I'm showing you is to show the arbitration clause now. My lord, please have a look at the arbitration clause at 337. My lord, it says, in the event of any claim dispute arising out of in connection with this agreement, that is this restructuring agreement, including but not limited to the existence, validity, kindly see, performance, interpretation or termination, my lord, of this agreement, or as a consequence of its nullity. My lord, everything, the wildest possible of Renusagar, my lord, is given. One cannot imagine more than this. Nullity, alleged breach of this agreement between the parties, then parties agree to refer to arbitration.
Yes.
My lord, on the same date, a separate arbitration agreement is entered into. That is on 31st March 2021. The reason why I am telling you all this, my lord, we terminated this master agreement by letters before the administrator, they admitted, yes, this is not valid. This is not valid. And they said, we go back to one loan agreement 1, 2, 3, where, my lord, my amount is 1,200 crores. They admitted in correspondence before arbitrator, in 3 correspondence, divisional arbitrator. After it comes out, and I give this, they said, no, 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 your loan is this much now. That is, my lord, after I give this notice before the section. That is why I'm drawing your attention.
But
What is the scope?
these agreements are entered into by you.
Yes, yes, my lord, I'm saying, I will show you. I'm only saying, they say there is no arbitration. Therefore, I am showing you that everything is under the arbitration. That is why I am showing you. I am agree, my lord, I have to abide by the agreement, whether what has happened in fraud, that is no, but I am going by the legal aspect of it, because other things have to be taken care of other agencies. My lord, I am only following the law as per the
No, I
agreement.
was only pointing out, Mr. Bose, to the
Yes.
extent that the amount, as far as the amount.
Yes, yes, absolutely right. Therefore, I am showing you the amount is this, 1,200, not this reduced amount. I am aware of this, my lord. That is why I am showing you, my lord, whether it is too reduced. Because I say I cancelled this agreement and they accepted the cancellation and they say the amount is that. Those documents I want to show you. My lord, this is the reason why it's roundabout. Your lordship must be wondering why I'm showing you.
No,
but,
no, I
yes.
just wanted to understand.
No, that is why I'm showing you. My lord,
389.
the arbitration agreement, my lord, is 389. On the same date, arbitration agreement. Volume 3, yes. My lord, clause 2.1, or rather, my lord, or A, in 389. Pursuant to request, sir, parties have entered into master restructuring agreement for restructuring the loans into a consolidated loan, total loan, mentioned in Schedule 1. Then, my lord, kindly see page 390, a very wide arbitration clause, although there is one in the master restructuring. My lord, it says any dispute claim arising out of in connection with the total loan. My lord, a new term arises, total loan. And any of the financing documents. My lord, I have shown you what the definition of financing documents is. Including but not limited to exist is the same, including termination or concept, or arising out of any breach of any of the financing document. Has your lordship found that? And then 2.2, the arbitration shall be determined by sole arbitrator appointed by the lenders tribunal, shall be deemed to be mutually chosen by the, now of course this validity of this thing will have to be decided. That's neither here. My lord, please come.
1.2
Yes, my lord.
Interpretation, financing
Yes.
document,
Oh, yes. My lord, 1.2, to the extent not expressly excluded, provisions 1.2 of restructuring shall apply to this agreement. What is 1.2? My lord, drawing your lordship's attention back to, my lord, the restructuring, it means any of the financing documents. My lord, 1.2 is at page, my lord, 1.2 is at page 1.2 বলছি কত হলো না রিস্ট্রাকচারিং এ না
restructuring page 292.
292 madam my learned junior says 292 yes
Interpretation of all these
yes
include
my lord 292 total loan means my lord has your lordship found
Just
292 এটাই তো
yes.
My lord, total loan means restructured loan and the FITL, all financing documents. And এটা কি দেখাতে চাই? হ্যাঁ, so how is it relevant? Oh,
with the both the agreement,
yes.
arbitration agreement
Yeah.
and the
Now, my lord, this is so far as the arbitration. So I have given you the clause. It says any of the financing documents, and my lord, financing documents at page 288 of the restructuring, my lord, refer to all the loan agreements which I have shown you. Then, my lord, 288. And dispute is very wide, it covers termination and nullity. Now, my lord, I don't want to, just you may note it, my lord, the hypothecation agreement, whatever it's worth, my lord, because current assets, everything, without saying anything. You can take everything. For a person who has nothing, it's everything. So, my lord, hypothecation agreement is at page 105, my lord, of the loan agreement 1. You may, if you want to note, my lord, otherwise I will give you a list of dates which I have prepared, my lord, giving you all the page numbers. My lord, hypothecation agreement of loan agreement, page 105, all part of financing documents. You can just make a note, my lord, not even
105.
105, my lord.
It's agreement and conditions for loan.
Yes, my lord, it's a sort of my lord, my lord, 105. Yes, it's called, my lord, unregistered deed of hypothecation. My lord, 105. Have you found it? My lord, my lord, my lord, it's volume 1. Oh, I am sorry. I think you must be looking. এটাই তো? Have you?
Is it in the supplementary affidavit?
It is supplementary. It is part of. No,
supplementary affidavit.
no. It's my lord, it's part of the section 9 application petition, which is fat volume by itself, my lord. 105, my lord.
105. Must be it. Yes.
My lord, have you found it, my lord? My lord, it's called unattested deed of hypothecation.
Yes.
My lord, lordship may read everything, but will not find anything because it says everything. So, my lord, the hypothecation agreement loan 2, page 199, and hypothecation agreement loan 3 is 133. And for the master restructuring, 347, identical language. My lord, all identical language. Now, my lord, what happens is interesting. Administrator gets appointed. Now, my lord, NCLT proceeding in October 2021. Now, my lord, we write a letter at page 379. My lord, 379 probably you will get in volume 2. Volume, my lord,
379.
Main volume 3.
oh, main petition. Main
Yes.
petition.
Yes.
Koto?
I got it.
379.
That's just
Yes.
1st January.
Yes,
Saturday.
my lord, please have a look, the date. My lord, immediately after administrator is appointed, we shoot a letter, my lord, on 1st January 2022. My lord, right at the bottom. Right at the bottom. It's 1st January. Have you found, my lord?
Yes, yes.
Yes. We write it to them saying that, look here, my lord, kindly see, we refer to the loan agreements 1, 2, 3. My lord, have you found this?
Yes, yes.
My lord, we refer
1, 2,
not
9,
to any restructuring.
Hmm.
We refer My lord, kindly see, we'd like to refer as per advice of the statutory auditor, management has reversed the restructuring that affected on 31st, interest due to be paid, to be adjusted against DSRA balance, debt service reserve balance. My lord, has your lordship found that?
Yes.
So we clearly say that, look here, you have reversed because we have something wrong. And this is what is due and payable. And the last line at 380 is important. Please confirm. You have to please confirm adjustment of gross net after deducting from DSRA balance. Otherwise, please pay immediately. Send your reply today. My lord, has your lordship found?
Yes, yes.
Yes. To that, my lord, if there is no restructuring, my lord, yeah, my lord, absolutely caught. Now, my lord, the reply comes on 10th January, just at 379.
Above you.
Yes. In response to your email, my lord, has your lordship
Yes.
found? Regarding interest and restructuring, we are certain and reiterate our commitment to paying the loans in the manner agreed earlier. Of the requirements restructuring wherein
I think this.
yes, something
We understand.
is to be transferred to Shrey is still pending.
Has to be understood.
Huh. So there is DSR which is pending. The balance is to be repaid and refinanced through our power distribution business. Due to reasons beyond control, delays made to COVID, we are unable to transfer these FCDs.
This is fully convertible debentures.
My lord, the
Restructuring.
FCDs refer to those Hiranmoy shares of convertible, which I will show you. It is old management of Shrey itself. Hiranmoy. My lord, money coming out. I will show it to you from their balance sheet. That, my lord,
Circular transaction. Complete circular.
money coming to only shareholder to purchase, who is the only shareholder of Hiranmoy, is going this way and going out, my lord. So one is caught. This one there, so they have to admit to something. So they are admitting, unable to convert. We request you to allow something to transfer FCI interest within 31st March 2022, which means, my lord, under the all three agreements, and says, we are well aware you are entitled to take action against DSA, action for DSA adjustment. Ensure smooth financing. Kindly consider request in respect of DSR adjustment. DSR adjustment is under the, my lord, first agreement for 1, 2, 3. The fact that we have changed the master restructuring, they do not dispute. Well, there is further to this.
There is another admission. 378 third email that we have adjusted.
Then, my lord,
the DSR.
my lord,
370.
then comes speech 378. This is 20th June. Yeah, sorry, January. We say we have adjusted the following dues against the three agreements available at gross. Please send us GSA letters on the company letterhead from the customer. So, my lord, we say that, look here, we have already adjusting. Now, in your letterhead, you please tell us that you have agreed to this. My lord, kindly see, I have adjusted all these given particulars of the three agreements, and they reply to this on 21st. My lord, the 21st January letter is at 378, just above this. My lord, 21st. You may adjust gross interest. My lord, have you found 21st letter? Just above this. Above 20th. Small, one-liner.
on 21st.
My lord, have you found?
Yes.
My lord,
378.
yes, 378. There are two. My lord, just above 20th January.
You may
There is 21st January.
Yes.
Yes.
You may adjust gross.
Yes, you may adjust. Yes, you adjust. Confirming this. To that we say, by email it won't do. You give us a proper letter. My lord, that is coming next on 25th January. My lord, page 378. My lord, has the lordship found? We say, please find attached as requested, and there is some, my lord, adjustment given. And this is, my lord, your lordship will find at 381. We say, give us a formal letter. My lord, the formal letter comes at 381. Now, in their letterhead, etc. It is Tuticorin, that is the respondent, and he says, with reference to email, you may adjust with adjustment of future interest. So, my lord, confirmation of the fact, restructuring, it's all bogus. My lord, the main thing is that a loan agreement, there's further story to it. Now, my lord, then, my lord, on 11th August 2023, we come out of insolvency. The Sri comes out of insolvency. That pleading is there in para 2 petition. Your lordship may see. We send a demand notice now. After coming out of the clutches from the Reserve Bank Miller side, coming out, the demand notice attached 395. My lord, 395 is the demand notice, volume 3.
Yes.
You say, we say basically, you pay. This is the shortfall, etc. If you don't pay, then we will institute proceedings.
This table is important. Table says about the 3 contracts, the required DSR we have seen.
Yes.
Well, those
My lord, we mention about 3 contracts.
the table.
The table.
At page
Yes.
396.
We mentioned about the DRS, the shortfall. The shortfall.
It has to be 35 crores. It was only 63 lakhs. Or
And to that, my lord, there is a reply on 21st November 2023, page 397. Next page. My lord, please look at the reply, 397. He says, with regard to, due to crash crunch, DRS balance has been replenished since our stabilized. Further, it is submitted in terms of such and such said loan agreements due to shortfall, etc., etc. My lord, there is crash crunch, I understand everything, but there is no restructuring.
the first line to be important.
My lord, the
First line to be complying.
my lord, and it also says in the first line, we like to bring, we are complying with the terms of the loan agreements. My lord, 1, 2, 3. There is no mention of the master restructuring. My lord, has I.
Yes.
Then, my lord, when I came before filing this application, when I send this notice, they dispute. That, my lord, completely, my lord, this is the turnaround. 11 July 2024, page 398 is my demand notice.
Recalling the entire.
My lord, I am recalling now because DSR is not maintained. Under the terms and conditions, I am entitled to recall the entire loan. My lord, this is my notice recalling the entire loan.
Paragraph 9.
My lord, paragraph 9, you can see, because you have not maintained under 1, 2, 3 DSR, I recall the entire loan. And it becomes 1236.
With penalty, interest.
With penalty, interest, whatever. Now, my lord,
And 401 is the chart that we have.
The reply comes. কোথায় আছে? এই reply-টা কোথায়?
Page 406.
Huh?
406.
My lord, the chart is given at 407 and at 406 comes the reply. They completely now say that there is a, my lord, kindly fall back on the master restructuring agreement. My lord, kindly see. কোথায় বলেছে?
Whitaker has rightfully in the letter has denied an occurrence of default.
Uh.
বলেছে there is no default.
Hmm.
There is no non-compliance of DSR in addition to our concern that we are not entitled to liable to pay.
My lord, in the affidavit in reply, they are disputing it has been restructured because of the this master restructuring. So amount what you are claiming is all wrong. There are two defense, my lord, and the other defense is, my lord, yes, there is no arbitration clause. Now, my lord, believe you have something, my lord.
Yes,
Next day I will only show you that Hiranmoy, Tuticorin,
Same.
Srei are all same. Not you Srei, old Srei are all same from their balance sheet. Now the question then I will be arguing. I'll tell your lordship. What can your lordship do after with this
Yes.
argument? Ours is, my lord, a money has been taken 1200. For that, my lord, I will write a judgment under, my lord, that in section 9 powers are wider than order 38 rule 5. That you are maybe aware that there are two conflicting sort of judgments of the Supreme Court. But with great respect, Sanghi and Ki, great respect, some courts, our court has followed the previous one. Some courts have wrongly interpreted the Sanghi judgment to be a judgment of similar strength. The previous judgment was a 3-judge bench. Sanghi, Justice Shah and forget, was 2-judge. In one of the Delhi High Court judgments, it was wrongly said same strength, therefore later will prevail. Later will prevail. No, it is the previous judgment is 3-judge bench. Your lordship may make a note of this. This is a question of law, I will just say, and then leave it to your lordship. Whatever may not, your lordship will do, whether they direct them to furnish security. Who will furnish security, I do not know.
What security?
And what security, that also. But let them argue.
How will they furnish the security?
Who is the person who will furnish the security is more appropriate. I will cite, of course, a judgment that when these are not there, the lordship has some matter, I believe, as direct. You've taken breach, you furnish security. I don't care. some matter. I was told.
We'll keep it. When do you want, Mr.
Melod,
My lord, any day after 9th, I'm instructed Mr. Ray is in difficulty till the 9th. Any day after 9th. My lord.
so yes, so I will complete a little take
12th,
time.
12th or 14th, my lord. 12th, 14th.
Convenient.
15th.
Or I can complete my part and then whatever is convenient.
Very well. No difficulty.
When do you want 14th?
14th or 15th, my lord. If it could be 15th.